Okay, so here are, I'm going to give you both at the same time. So here's chapter 3 and chapter 9. Is it what's right here or is that your book?
Oh, no, this is not that.
Okay, so everyone has a copy? Oh, thank you. So we can keep going. Jep, will you do a sheet for attendance for me? Okay, perfect. All right, so we start off with our distinction between civil and criminal law. And hopefully by now, like between, because I know I have a couple of you in other courses where we kind of covered this a little bit. But we just give a little bit of an overview again about the general distinctions between the two. So in criminal law, who initiates the case? Yes, sir?
State or federal government.
That's right. We use the term state kind of loosely. So it could either be a city government, it could be the state, it could be district, okay? So very, right, and then the way that we look at the action that's done by the person who's being charged is as if they have wronged not just against that individual, but the entire community, society, okay? Does that make sense? And then in the context of civil law, we're talking about private rights, private parties, okay? So here, this is my individual suit against you, okay? It might have larger implications, but we don't look at it the same way in terms of being a wrong against the entire society like we do in the context of criminal law. All right, so then we get an idea of the structure of the it's doing that time thing on me again. Let's see here. Transition. What all? Let's just take it off the clock and put them on. Make it be like, just in case it doesn't do it. Okay, so we have a structure of our federal court system. So at the bottom level here, we have. Okay, well that was interesting. So it'll put it back on there. Okay, so let's. All right. So apply to all, nothing. How about that? Okay. Let's try this again here. Okay. So the bottom level, we have what we're going to call our trial courts, okay? Trial courts. Courts of Intermediate Appeal, the Circuit Court of Appeals, and then at the top, of course, we have our U.S. Supreme Court. Okay? You okay with that? It's kind of a refresher, we already know that. Here's your typical state court system. Here we have a courts of limited jurisdiction here, general jurisdiction, appellate court, Supreme Court. So particularly in Washington, what courts are going to be here?
Small court.
Huh? District court? District court, what else? What's going to be in the very bottom? Have we done the triangle in here?
No.
No? No triangle?
Municipal.
Municipal court? Okay. And then Superior Court? Okay. So I don't want to take anything for granted, so I'm going to do this quickly, but nonetheless we'll do it so that we have a new clear understanding. And that's important for us because when you're gathering collecting information, you want to kind of know, like, what court is this case potentially going to be in? So the very bottom here, we're going to have muni court. Okay? We're going to describe the jurisdiction of muni court as Anybody know? We're going to describe the jurisdiction as limited, LJ. Limited jurisdiction because it's limited in terms of the scope of matters it can hear. All right? We have municipal courts in the areas where the population, I think, is less than 400,000. It's either 4 or 500, but it's not more than that. Okay? What kind of cases can we hear in muni court? So traffic infractions. What else?
Domestic violence?
Okay, so we can hear DVPOs, domestic violence protection orders, misdemeanor offenses, misdemeanors. These are criminal offenses. These are our smaller criminal offenses. Not necessarily less important, but in terms of the hierarchy, our smaller criminal offenses, okay? And what do we mean when we say misdemeanor? You guys remember?
Something where the jail term is less than 365.
That's right. So we're going to classify the things based upon the maximum penalty associated with it. All right, so we're talking about misdemeanors. We usually have 2 categories. So we have gross, and then we have misdemeanors, or sometimes you'll hear people say simple misdemeanors, okay? For your gross misdemeanors, the maximum amount of time you're going to get in jail is 364 and a $5,000 fine. If it's a simple or regular misdemeanor, then the maximum amount of time is 90 days and a $1,000 fine. It doesn't mean that this is what you're going to get. It just means this is the maximum penalty associated with it. Now, you commit multiple offenses, and you're convicted of multiple offenses. Do you see how you might potentially get more than 365? Yes? Okay, if they were to run it consecutively or something like that? Okay, yes ma'am.
Is it like an either or, like they either pay or they go to jail, or?
No, not necessarily. It depends upon the facts and circumstances of the case. It also depends upon if there are mandatory minimums that are imposed by statute, and also depends upon the process of negotiation. Are we okay with this idea? Okay, so let's keep going. What's the next level court?
Superior court.
I'm sorry, I thought this might be a review. So let me know if I'm, but because the way our program is structured, you might not have had this, so I'm okay with going over it. Are you guys okay? Should we finish this?
Yes.
Yeah.
Okay. All right, so the next level is going to be muni court. Excuse me, I'm sorry, district court rather. District court. Okay. Now what do we have in district court? Do you say more crimes? Yeah, we got some more crimes. Yeah, so district court, within district court, we're going to draw a box over here, okay? So housed within district court is small claims court. Small claims. These are civil cases. The amount cannot exceed $5,000, and we are without counsel. We don't have attorneys representing parties.
So do lawyers never do small claims, or is it just like a
So
thing?
So here's the thing: you might come see a lawyer and pay them for assistance in helping you get your case together, but no, a lawyer is not going to appear in court for you.
That's like Judge Judy.
That's like Judge Judy or the People's Court. All those exactly. All right. So what else do we have in district court here?
Do they do divorces?
Nope, we don't do divorces. So, but what we can say is all this other stuff that we do in muni court, we also can do here, okay? In addition, we can hear PC determinations for our felony cases. We're not going to hear our felony trials, our felony criminal trials, but we can hear PC determinations. What's PC? Probable cause. Okay, so the person is not just waiting indeterminately in custody. We can have this district court judge make a determination as to, okay, there is sufficient probable cause to hold this person over for additional charges or so forth, okay? All right, we can also hear civil causes of action. So civil cases, as long as the amount does not exceed $75,000. You okay with that? Oh, we can get married here. We can change our name here. Okay? We can get an anti-harassment order here.
An anti-what?
An anti-harassment order?
Oh, right. Is that different to?
Yes, it is. BBPO, these are like familiar relationships, boyfriend, girlfriend, mom, dad. Anti-harassment is gonna be more so removed parties. These are the neighbors. There's no sort of blood or intimate relationship. Okay? All right, so we got community court. Now, we're also gonna describe the jurisdiction of district court as limited as well. Okay? So LG, limited jurisdiction, because the scope of what they can hear is limited. Niku, I know you got this, so sorry. Okay, keep going. All right. So what's next? Superior. Now we have Superior Court. What are we going to call Superior Court?
Is it limited as well?
Germany.
Huh? Is it limited as
Nope,
well?
I heard something else.
General.
General jurisdiction. And we're going to say that because Superior Court can hear anything. They can hear all of this stuff down here. This is also where we're going to hear our divorce cases, our adoption cases, our probate cases, our baby daddy cases, our paternity action. All right, we can hear misdemeanors. We're also going to be able to hear felonies here. Okay. Now, we talk about our felonies. Our felonies have a classification system too. So in Washington State, we have Class A, Class B, and Class C. Okay. Again, the classification is going to be contingent upon the maximum penalty that's associated with it. So for our Class C, we got 5 years, and is it 10,000? Yes, it's 10,000. Then we got 10 here and 20,000, and then we got life here and 50,000. Okay? So these doesn't mean that this is what you're gonna get, but it means that these are the maximum penalties associated with it. Okay? Class B might be our theft case. Theft in the second degree, first degree, A, murder, racketeering.
Are you saying theft of the second degree or?
Theft in the second, so theft in the second degree.
What does that mean?
So that would mean where
Armed robbery?
it's $750, where the value of what was taken is $750 or something. And we'll look at examples of this, because what we're going to look at is and so every single, in the civil arena and in the criminal arena, so every single crime or cause of action, there are going to be what we call elements, what we have to prove in order to support that cause of action or that crime. Okay? And then, so when we look at the language, that's the information, that's how we're going to use and apply that information to the facts. Okay? And we're going to talk about this in more detail. All right, okay with this idea right now? What's the next level court? Yes, that's right, Court of Appeals. Court of Appeals. And then what's on the very top?
Supreme?
Which Supreme?
State. Washington State.
That's right, Washington State Supreme Court. All right. Rules of procedure. So, rules that govern the adversarial process, and our courts are called rules of procedure. So these are the rules that tell us, okay, where do we file, how do we file, what court, who gets what copies, how many inch margin should be on the pleadings, all that kind of stuff, okay? Who gets served, how do we serve them? We have federal rules of criminal procedure, and then we also have our state rules of criminal procedure. And then in addition, we also have what we refer to as local court rules. So we got a whole bunch of different rules that we're responsible for knowing, okay? And that's why this chart becomes really important, because you want to make sure that the case that you're working on, you're looking at the right rules for that jurisdiction that you're in. And lots of times as paralegals, we're going to you. We're dependent upon you to know the rules of that particular court, and beyond that, even within that court, how that particular judge likes his or her documents and exhibits and things like that. So I keep using this phrase, causes of action. In civil law, we identify certain theories or causes of action that a private party can bring against another. What might be an example of a civil cause of action? Yes, sir?
A breach of contract.
Breach of contract. Okay. You okay with that idea? Yes.
Could that also be like legal malpractice type?
That's right. Exactly. Car accident, personal injury, civil cause of action. Okay with that? All right. And again, a recognized cause of action is made up of certain elements or parts that must be pled and proven by the party making the accusation or the allegations. And we'll take a look at examples of this. But so far, we're okay with this idea? Okay. Remedies and damages. In a civil suit, the plaintiff is seeking some sort of remedy from the defendant. Most often it's money. But sometimes there are other remedies that we might be seeking, okay? But for the most part, we're seeking money, and damages can be either compensatory or punitive. When we say compensatory, what we're referring to are is the idea of compensating based upon actual loss. So, for example, we were involved in an automobile accident. I want to be compensated for the damage that was done to my vehicle. There is also medical bills or expenses that I incurred. I want to be compensated for that. Maybe I also lost time from work. I want to be compensated for that as well. The idea of punitive damages are damages that go above and beyond what's needed to actually compensate the person. So here what we're trying to do is actually make the person pay. We want to make them pay. We want them to be encouraged to do better or change their behavior. We want to send a message. And the best way to do that, get it in the pocket, right? So what you should know about Washington State, though, is that punitive damages are only permissible. Basically, they're generally not permissible unless it's explicitly authorized by a statute. Okay? Yes, do you have a question?
I was going to ask, are there two types of compensatory damages? Because I remember in a previous class that they were talking about, in some states, compensatory includes certain things, such as like time lost at work, and in other states it doesn't.
Yeah, so it's always going to be contingent upon the jurisdiction that you're in, but for the most part, the compensatory damages are exactly this. Money damages that can compensate the plaintiff or make the plaintiff whole. They can be general, meaning compensation for pain and suffering, or they can be specific, out-of-pocket expenses such as medical bills, loss of wages. I would imagine that would, even though I wasn't in the class, I would imagine the point that might have been being made is that in some states, we're going to have some variation here about this idea of pain and suffering. In some states, you're even going to have there's a movement for tort reform where you even cap this right here. Because how can you quantify my pain? I'm feeling like I'm about $50 million worth of pain and suffering. So you can see how at some levels there's some debate about whether or not that gets to be a little bit arbitrary, right? But here, irrespective of what state you're in, like these are my medical bills. Yeah. My medical bills are what they are. Right? My lost wages are what they are. I can actually prove that. It's documentable. Okay? All right, we already talked about the idea of punitive damages. Criminal proceedings. So usually the idea is some sort of punishment. Now we talk about rehabilitation, which it should be about as well, but that's subject to debate. But the idea is that the bottom line is that there's the potential loss of liberty at issue. Okay? Anytime you're charged with a crime, you always face the potential of being incarcerated. All right? So crime may be a misdemeanor, punishable by incarceration for up to 1 year, or felony, punishable by incarceration more than 1 year. And we did our little scheme over here where we talked about the differences in the hierarchies of both of those. Defenses, am I going too fast? Are you all okay?
No.
Okay. All right. Defenses in a civil suit. For every civil cause of action that may be alleged, the defendant may merely deny the allegations. So if I just merely deny, what you can make a note of is that this is called a general denial. General denial. Okay, you also have the same concept of criminal law. It's just a general denial. No, I didn't do it. Okay? However, in addition to a general denial, sometimes the person may have what we're going to refer to as an affirmative defense. So loosely translated, what this means is, yeah, I may have done it, but there's something that excuses it or permits it, okay? Or there's something that, something under the law that allows me to escape liability, okay? And we'll talk about different examples. Oops, excuse me. Defenses in a criminal suit. To every crime with which one may be charged, there are recognized defenses. So same thing. I can do general denial, or I can have some specific affirmative defenses. Okay? Burden of proof, degree of proof. So big distinction between criminal and civil law, right? In the civil arena, our burden of proof is what? Preponderance of the evidence, which means what?
Reasonable belief that somebody's negligent. So it's kind of, in a criminal case, it's beyond a shadow of a doubt, whereas in a civil case, it's reasonable proof, or reasonable evidence.
Yeah.
More than likely.
Okay. Let's play a little bit here. Right, sorry. All right. And then let's mute this for a moment. Let's erase this. Yeah. Last night was Monday, right? Right? Monday's a long night for me and some other students here because, you know, we start off at 8 with an 8:30 class on Mondays, and then we have an evening class that doesn't get out until like 9. Okay? And so it was a kind of a rough class. So I stopped by the store and I picked up a bottle of wine. What else? So, I had some wine. I sipped a little something. I was feeling really good. And then I decided, okay, I'll go ahead and try to head home. Okay? Now, I'm going to put 0 here. And I'm going to put 100 here. Okay. So I sat in the parking lot of the Fred Meyer's, because that's why I bought the wine from, for a few moments. I just kind of sat there. Okay. My car's not on, engine's not running, nothing weird. I'm just kind of sitting there. Don't look at it. With me? All right. Officers in the parking lot. He's been kind of watching me. Right? He saw me go into the store. He saw me, Right, you with me? Okay. Now, he's looking like something's kind of not right about this, right? Now, can he stop me at that point?
No.
No. But is he feeling something?
Yeah.
He's feeling a little something, okay? That little something that we're gonna say he's feeling, we're gonna call that a hunch. But you see where I'm putting hunch on the scale? It's nothing. You didn't do anything. With me? All right. But let's say that let's say instead of leaving, now I go from the Fred Meyer's to, is there a bar around here? I don't know, let's just pretend there's a bar next door, okay? And let's say I walk into the bar like this, right? He happens to see me, he goes on, does his stuff, whatever. He's passing that by the bar later on, so dang, there's that same woman again. And now I'm like, and I'm by myself, okay? Right? And I look a little strange, right? And I'm coming from a bar, right? Okay. Now, is there anything here?
Probable cause.
Back up.
Yeah.
Probable cause for what now?
She has a
This
partner.
cause, right? Haven't done anything just yet?
Has he seen you consume
I'm just-
alcohol?
No, he hasn't seen me, but what he does know is that when he saw me earlier, I walked into the bar like this. And now,
Yeah.
okay, all right, you okay? Now, we're gonna say that he might have what we call, can he, does he have more than a hunch right now?
Oh,
Yes.
Can he actually objectively articulate something now?
Yeah.
So we're gonna call this an articulable suspicion. Are we okay with that idea? Because is he suspecting something? Yes. But now, like we said, this is more than a hunch. He actually now has some observable, reasonable facts that he can articulate as to why he might be thinking I'm either engaged in or about to engage in some criminal activity. You okay with that? Okay, but have I just yet?
No.
No, not yet. Okay. But can he approach me?
Yes.
Yes. Good evening, ma'am. How you doing? Where are you going? You okay? Oh, I'm fine. Just had a rough day. All right. Well, why don't you go ahead and maybe have a seat here? You know, why don't you? There's a coffee shop right there. You probably want to, have a little coffee, whatever. Take a little time before you drive, right? With me? Okay. So let's keep going. So articulable suspicion. Now, let's say, so he waits a couple hours, dedicated officer, okay? Now he sees me, I did not go to the damn coffee shop, okay? I'm getting in my car. You with me? And I'm sitting there. Anything yet?
No.
Not yet, right? Does he still have that articulable suspicion?
Yes.
Yes, he does. Okay? So now, I start my car. With me? My engine's going. And I start to move through the parking lot. I'm driving okay. Is he have a reason to watch?
Yeah.
Yes. Okay, we're right. Now I turn without any signal onto the main road.
Yeah.
Right? And then I start doing like this in the lane. Now, what do we have?
Probable.
Now we got probable cause.
Yeah, happened to me actually.
Probable cause to actually stop and perhaps ultimately arrest. Okay?
How far can they follow you based on your articulable suspicion?
As long as
Before
they-
you can actually-
Yeah.
As long as they need to.
It's not against the law.
That
at
was
all.
2 months. They
Huh?
didn't follow you for 2
As long as
months.
they need to. You know what they're doing? Because know what's gonna happen? You know what's gonna happen? This is a constitutional issue, right? So if I don't have PC, if I never had this, that's gonna raise a question about my contact here. You with me? So for example, if I just walk to my car, I'm fine, I get into my car, and he stops me, right? And then maybe even say ultimately there's an arrest that's made. Well, guess what my attorney's gonna do? He's like, well, what was your initial basis to even make contact with this woman? You with me? So now we get to challenge all this. We okay with that? All right. So then we get to, so we're just talking about different, this is going to be our, what we call our spectrum of burdens of proof. Spectrum of different burdens of proof, okay? Right here, I'm going to put 50%. See where all this stuff is on this side? Now, we got here because I was asking you about the idea of what the burden of proof is in our civil cases. And so what did we say the burden of proof was? Because I heard a whole bunch of, something about negligence and reasonableness and all that kind of stuff. Yeah. So, in our civil cases, the typical burden of proof is going to be preponderance of the evidence. Where is that going to go on this number scheme here?
51%.
All right. Let's make this 51. Oops. Let's have 53. And we're going to put preponderance of the evidence. But what does that mean? What does preponderance of the evidence mean?
If you have, this might work. If you have 51% or more, then you have to prove 51% or more.
Yes? But what's the other language that we can use to flush this out?
More than likely.
That's right, more likely than not.
More
More likely than not. You okay with that idea? All right. Now we have another burden of proof in the civil arena too. And it's higher than this preponderance of the evidence. What's that standard?
Beyond a reasonable doubt?
Nope. That's criminal burden. We'll get to that. So you're going to put it here. Now, and I want you to pay attention to the fact that I'm not going to put any more numbers up on the board. Okay? So this is going to be clear, cogent, and convincing. Okay? All right, some cases. Some civil cases where this is going to be our standard. Defamation. Got an example of libel, example of slander. Libel, you wrote something bad about me, you drew something bad about me. Slander, you said it. Okay? So these are examples of civil cases where that burden of proof is going to be higher. It's going to be that clear, cogent, and convincing standard. Another example is where we have a party contesting a will. Arguing about the money. Another example is going to be fraud, civil fraud cases. This is the standard. Okay? Another example, dependency proceedings. What's a dependency proceeding?
Like your parents, like whether your parents are within years.
That's right. So this is where the state is coming in and suggesting that you as the parent are incapable of taking care of your child for some reason. Okay? And then over here, notice I didn't put it at 100. Okay? Because we kind of say beyond the shadow of a doubt. That's not what the standard is. It's simply beyond a reasonable doubt. And this is our burden of proof in our criminal cases. in any criminal case that we have, whether it's a misdemeanor or a felony, the burden of proof is going to be that beyond a reasonable doubt. Now here's how you can understand the magnitude of that being the highest burden, okay? Because there's really no other way to kind of talk about the significance of this burden other than to go back and to analogize it by the burden that we have in dependency cases, right? Do you love your parents, right? Or the person that you call your parental figure, right? Do you think they love you? Right? Okay. Well, in an ideal situation, they love you, you love them. You give birth to something, and you desire to keep that child and nurture it, put it through school, right? With me, share all those special moments. Presumptively, you care about your family, right? So the idea that the state can come in and say, ma'am, excuse me, but we determined that there needs to be a cause of action filed against you because we are finding that there's reason to believe that you, even though you gave birth to this child, you are incapable of taking care of that child. You with me? So we're going to take this child from your home and put this child into some other person's custody, who may or may not be a family member. Is that huge?
Yes.
Come on. Is that pretty significant? You get how big that is? And I birthed this child, I brought the child into the world, and you're going to think that I can't take care of some stranger? It's better capable? And it might be legitimate, right? But that's sort of what we're talking about. And the standard there is clear, cogent, and convincing. Right?
What percent is that?
We're not talking about percentage.
Okay.
All we need to understand is that it's greater than the preponderance of the evidence. But in that context, though, look at what we value more. Look at what you value. Look at this thing here, this spectrum. What do you value more? More than even your children and your family. What do you value more?
Your life.
Your life. Your liberty. Because that's where the standard is the highest. It's not clear, cogent, and convincing. It's beyond the reasonable doubt. So as much as you love family, as much as we think our family loves us, in our system, what we say is, we love you, family. If you want to take my kids, you better meet this standard. But if you trying to take my life, my freedom, no. We need beyond the doubt. You with me?
I think they should be the same.
You think they should be the same? What do you think about that? Why do you think they should be the same?
Well, because for a lot of parents, if they don't have their kids, that is their life.
Yeah.
To play devil's advocate for the other side of that, I think if you hold it to that standard, it's really difficult to see inside of a home and collect evidence inside of a home that's protected by the person that's being prosecuted, possibly for negligence. So I can see both sides of that. If there is an abusive parent, it's really hard to gather beyond a reasonable doubt evidence.
But when you place a child in foster care, you take their freedom and you take their life as they know it, just the same as if you were to put someone in prison, because a lot of homes are like prison.
All right. So that's some good back and forth.
I don't agree.
Yeah. Okay. Yes, ma'am.
And it's not because I don't agree on the fact that when you take your kid from their parent, it turns their whole world upside down. But some kids need to be taken from their parents. And if you have to prove beyond a reasonable doubt that that parent is abusing that child, more times than not, the court's not gonna go through all of that just to prove it. Like, if the standard is too high, a lot more times than not, they're not gonna want to go ahead and take the case, because it's hard to prove beyond a shadow of a doubt that the parent is abusing them if there's no bruises or marks or anything like that.
Well, remember, the standard is not beyond a shadow of a doubt. It's beyond a reasonable doubt. And what I would sort of ask you to consider is that while there may be a significant emotional impact right, in the process of taking a child away from their home. And while that home may pose challenges and difficulties, sometimes unfortunately even worse than the circumstances that the state was seeking to take them out of, nonetheless, that's a little bit different than you being taken to a place where you're gonna be behind bars, where your entire sense of privacy is gonna be completely invaded, where we're gonna have you open up your mouth, stick out your tongue, bend over, let me look in between areas of your, you follow me? And then for an extended period of time, depending on the time. So there are different ways to look at it, and you're certainly entitled to your own viewpoints, right? But what our system seems to recognize and appreciate is that this idea of personal liberty, this is huge. Because if I don't have this, I can't even get to here. I can't even do this. Do you follow me? If you compromise this over here, then I'm precluded from even participating, from even being an actor on this stage over here. Okay? All right. So next we transition to different types of evidence. All right. So ways evidence may be presented to the court. So in any one of these arenas, whether we're in the civil arena or the criminal arena, we got different ways of classifying evidence, all right? We got evidentiary rules that are going to dictate how we get information into the court. But here's some general categories. One, we have testimonial evidence. So we have a witness in court on the stand talking. Testimonial evidence, okay? Documentary evidence, paper stuff. Real or physical evidence. So these are actual objects, okay? This is the phone that she used to bash him over the head, right? This is the real object. Demonstrative evidence. This might be in the form of charts and graphs and diagrams, okay? Look at that again. All right. You guys, I'm going to encourage you to try to be very, very open-minded, okay? I sense your frustration with our earlier discussion. I'm not saying you have to agree. I'm not saying you gotta buy it, but if you're gonna be in this profession, you gotta operate with an open mind. And when you speak or when you're in the presence of your attorneys, clients, they need to feel and believe that you understand and appreciate the system in which we operate. Because that's what's going to give them confidence in you working on their case and give them confidence in that attorney that's working on that case. And beyond disagreement here about something as fundamental as just the way our system is structured, because this is our system, that's it, right? I mean, absent some real big revolutionary, this is kind of steady, right? But can you imagine beyond this, on a baseline level, you're going to get some cases and some facts that are really going to upset your conscience. And you're going to have to figure out a way to appropriately and professionally contain whatever your emotional reaction is and go with the flow. Right? People, I prosecuted sexually violent predators and called them sir. You with me? You gotta be able to do it. You gotta be able to pull it together and maintain a calm composure. All right? You might even be working with a child victim, and you can't sit there and cry while they're giving testimony. While you're sitting next to counsel's table assisting them. You're gonna cause a mistrial. With me? So you gotta be able to have these sort of conversations and debate with people and disagree and move right along. Okay? All right. The next concept that you're introduced to is the idea of administrative proceedings. I would encourage you to take the course on administrative law. There's an administrative law course, 200 level course when you get to that point. It's really good. Whenever an agency action is to be challenged on appeal, it is necessary for the legal professional to be familiar with So the enabling legislation, the rules and regulations, the Administrative Procedures Act. What's an example of an administrative agency? What's the example?
EPA,
Huh?
EPA.
Yep, think with something even more basic to you right now. How'd you get here? Did you come in a vehicle?
DOT.
Department of Transportation, Department of Licensing? Okay, all right. Let's see, Department of Health. All these are agencies, administrative agencies and bodies, okay? What's really interesting and cool, right? Some of these, like Department of Labor and Industries, some of these you can actually even appear at the board and represent clients and question witnesses, produce documents.
Is this, in conjunction with the new?
It's not.
No.
So that's going to expand it. So right now, the way that it is, so she was asking about the Triple LT program. So right now, you can only do that sort of assistance of an appearance before a board if it's authorized by statute. Okay? Triple LT is going to seek to expand the scope of that. All right. So then you get an idea of the administrative steps. We're not going to spend a lot of time here on this, but this is here so you can kind of have an understanding of the general process. You got an agency action, got a petition or complaint that you file, you get a hearing before an administrative law judge, you get an order based upon that, then you can appeal to the governing board or agency, then they're going to issue an order, and then you can go to Superior Court. I have to be honest with you. At the Department of Labor, when I worked in the AG's office, and so we get so these are the LMI cases that we're doing. All right, so here you have witnesses or depositions and all this kind of stuff, okay? When you get to the appeal that's here, you know what you do? You have a jury, but you don't bring in the witnesses. You read the transcript. And so the big joke is the party who wins is the party who reads the best. It's crazy. All right. Crazy. All right. So methods of alternative dispute resolution. ADR. This is a big and growing field, actually, particularly in the context of family law. You have this idea of collaborative law, parties trying to work a little bit, to work better together to resolve issues without all this animosity and expensive litigation. Yes,
I'd
sir.
actually like to focus on that some. That's pretty much, I like the idea of the concepts.
Yeah.
I really like it. It saves money for both sides.
Yes, it does.
Courts and-
Yes, it does. Yeah. All right. So comparing formal and informal discovery. So what we're going to talk about, particularly when we move forward next week, is we're going to have different tools that we can use to get evidence and information about our case. And the tools that we can use are going to vary or be dictated by what stage we are in the proceedings. Okay? So up until this point before we file, informal discovery. Okay? There's certain things that we can do, and then there's certain things that we just simply cannot do until we're over on this side and the case is filed. Now we can always do the informal discovery, so that's why you have this far extended out. Okay? And then formal discovery, we'll talk about specific examples of that. Okay? Everybody feel the same? This general idea for right now? And like I said, don't worry, like, well, what's an example of formal discovery? I gotta get to that. All right? Some advantages of informal investigation. This is kind of carryover from last week in terms of why would we want to do some initial investigation. Make sure we have our good facts, preserve witnesses, preserve information, make sure the case we're filing actually has merit and so forth. All of those same reasons apply. Sometimes there's no opposing party, just sort of stand in their way and get information. Sometimes we can be the first to get some really good, juicy information we need for the case. And then again, as early on as we can get information to help support our case, the better our chances are perhaps for some sort of settlement. Okay, so those are all good reasons as to why we take some investment in time informal investigation process. So some limits, the parameters of what is legal, ethical rules, scope of authority, the investigator's imagination, right? Because there are some things that, so while there are great advantages to informal discovery, there are going to be many things that you'll see that we can do and get by way of information once we get to the formal investigation stage, okay? And just the difference between them is pretty significant. Doesn't mean that you can't do anything right now, okay? So for example, we might be able to go to the scene for our client, right, for Rowdy, right? We might be able to start to try to run background checks on the potential witnesses that are listed in that narrative of information that we got about him, right? We could maybe get his, if we wanted to sort of paint a picture of who he was to the jury, maybe we might get copies of his school records or his, if he's won some music awards. Maybe somehow we're going to be able to make that relevant. See how we can get that through the informal process? We can through our client, just asking him or something. But there are going to be other things where we won't have access unless we're at the formal discovery stage. Okay? Because maybe it's going to require a subpoena. Maybe it's going to require an interrogatory. But we'll talk about what those things are later. So this is kind of something we went over last week. Objectives of pre-filing. So sufficient facts, provable damages, special pleading requirements if we have any, identify potential defendants, identify assets, questions of personal jurisdiction. So again, where does Mr. Rowdy live? Does this court have authority? Where does so-and-so live? Was this case filed in the proper court? Okay. All right, so that takes us through chapter 3. Now what I want to do, we started at 11:30, it's now 12. Let me give you this, talk to you about for 10 minutes, and then we'll take a break, okay? Is that all right? Okay. So, I'm going to give you a couple of different things here. Now, how your files are constructed in the field is really going to vary and depend upon the office that you're at, the agency that you're at, how much money they got, what your budget issues are, okay? But at a baseline, we can get an idea of how we might begin to construct these with our paper files, okay? Because even if we scan, once we scan, we're still gonna have a construction of files, okay? So we're gonna start here. Here's your case file. And I'm gonna give you some labels. Your task is, we got a lot of cool things we're gonna accomplish. On your own, not here with me, you're going to put your file together for our Rowdy case. Okay? You're not gonna need all of these labels. I just know where the scissors. I think I can kind of. What do you think? You kind of have them. You know what? Man, there's an office right there. We have some scissors if you want. Thank you so much. Okay, you need some of that. Here it is. Huh?
Why are legal documents longer than just regular documents? Why is that?
Because lawyers think they're special.
Also,
I know.
Also,
But then you have lots
when
of
you're taking notes,
Yeah, your legal pad.
legal size notes, like this, so if you want to file your minutes.
Huh?
They look like half.
Oh, come on. All right. Oh, yay, they had some scissors. Thank you so much for that, okay? All right. So now let's put a couple of these together. Oh, shoot. I know I didn't cut them. Because if you were putting them in the printer, I didn't want to mess up for you. Okay, so what you're going to do is you're going to print your labels out, and then you're going to bring me back what you have left over. I'll let you down. Okay. Bring it down. You see what I mean? Yes. Because I don't want you to kind of put it in your machine and then you make a jam because it's coming back out. There you go. There you go. This one, the other one? Yeah, okay. All right. Now, let's see. Chapter 9. All righty. So we already talked about the skills, we already talked about that. Okay, so what we really want to talk about is our investigation. What? Fix you. All right. So before we talk about our investigation plan, what kinds of stuff do you think we're going to collect as we conduct our investigation? Because the kinds of stuff that we're going to collect, that's going to help us come up with the categories that we want for our labels. So what do you think? What? Yes, ma'am.
Background?
Okay, so background checks? Is that what you mean?
No, like background before the crime happened.
Background, okay, so hold on a second. What would you call that? And what do you mean? Flush that out a little bit.
Behavior, client service, or.
Like the relationships he had with the people involved.
Okay, what's that gonna come in the form of? Huh? Biographical information? So is that gonna come in, so some of this stuff, the idea of discovery? So documents and information about the case that we get, right? Or we might have witness statements. You know what I mean? What else are we gonna do through the process of our interview? Are we gonna write some letters?
Yeah.
Yes? So we might have a label that's referred to as what?
Client?
Correspondence.
Yes. Okay. You see where we're going here? All right, so we got discovery, we got witness statements, we got correspondence. What else is going to be critical in here? What else do we want to make sure when we look in this investigation file, we want to have an immediate notation of what? Oh, okay, so discovery of evidence. Yeah. What else? How are you going to keep track of what you do in your case?
Okay.
How are you going to keep track? Yes.
Chronology.
That's right, some sort of what I like to call a case action log. And where do you think this is going to go in your investigation file?
The front.
Yes. All right, so now we're going to backdate some stuff. Okay?
You ready for the document? Don't give me the document.
Here you go. Down. Now you may need to make copies of this. So what we're going to do is, remember Thursday, I gave you the case, right? So you're going to look at the calendar, notate what day Thursday was, case assigned. Case assigned,
Are you talking
general
about,
overweight case.
are you talking about the case with the,
Our routing case, but what day was that?
oh, right, okay.
Well, it wasn't Thursday, it was Tuesday. It was
Yeah.
Tuesday, wasn't it?
What they
Yeah.
Yeah.
You okay with that? You know there? Why is this going to be important? How many cases might you be working on? A whole bunch. So somehow we got to keep track of what we're doing on our case. We're paralegal investigators, right? So we're going to have a notator every single thing we do on our case. So on Tuesday, what was the date? Whatever the date was, you're going to note that down. Case assigned, general case review. That's what we did. Okay? Today, we're going to draft our investigation plan. We're going to have a case staffing and investigation into case staffing and discussion of draft investigation plan. Here's our draft investigation plan.
I'm sorry,
Case staffing. So when you come, it's a very common term that you're going to meet with your lawyers and you guys are going to do what we call staff the case. Sometimes it's called a briefing. But basically, we're going to talk about the case, see what the issues
issues are, see where we are, what we need to do, what the status is. What you doing on the case? Oh, well, right now, I just got the case, I'm taking a look at the witnesses, I'm gonna get ready to start making the witness list. So that should be the next action on there.
So today, we're doing a case staffing and drafting an investigation plan. So in my file here, this is always gonna be what you find first.
You said case
There's gonna be
staffing?
pages and pages of this.
You said case staffing and investigation plan?
Yeah, so case staffing, and we're gonna drafting investigation plan. Okay. Now, what your thing looks like is gonna be different depending upon when you're moving on this case. You with me? So when we get to the end, when you submit this in, if yours has 4 lines on it, and then yours has about 2 pages, I'm like, wow, she did some work on this case, right? And then we might want to talk, because our client might be going down. Alright? Okay. I'm just messing with you, because you know that, right? Alright, are we okay with this so far? Okay, let's get some more stuff. Because we're just doing, so Mr. Rowdy, he came to us, alright? And he was like, you know, I think, you know, the police that came to talk to me, you know, I waived my rights, you know, I didn't think I had anything to hide, you know, so I just spoke to him. You know, so that's the statement that we got, okay? Everybody, you got your client statement, right? Remember the document that we read through? Y'all looking at me like I'm crazy? I gave it to you. Does anyone need copies? Okay, because we need that, we gotta have that. All right, and I think let's break here. I have that it's 12:36, we'll go 12:40 something, come back, like 5 minutes. You need more time, need 10 minutes? Okay. Let's just do 5 minutes and then we might even get out a bit early, okay? All right, let's see here. So you need our client's information. Oh my gosh, please let me have a copy.
Anything that you handed out that Tuesday, that was the only day it kind of missed.
Oh, okay.
I'm trying to do a doctor for my son. So.
No worries at all. I just don't know if I have a copy. Oh,
I have a copy.
You do? Oh, I have a copy. You got a copy or you got your own?
No, I had my own.
Okay, here you go. Awesome, there you go, ma'am. And then, okay.
Are we breaking?
Yeah, it's about 5 minutes and then we're gonna come back, okay? While you guys do that, I'm gonna enter in the grades for your first one by doing exercise. And oh, don't go make it. I can give this back to you. You want it? Are you gonna come back?
No, I have a.
No, it's okay. Let me just give. Can I give this to you real quick? Hold on 1 second. Let me just grade it, okay? Tell me your name real quick. Tell me your name. Sharon. Sharon. Okay, got it right here. 1 second. I'll be quick. Okay. Sharon. Okay, here you go. Sorry about that. Here we go.
Did you give anything as far as the actual case itself, or this was it?
What's the witness statement and background? So would we log, any time that we spend on this, basically?
Yes.
Okay.
Yes, sir. Katrina? Austin?
I think I misunderstood. Did you need to put an all together?
Yeah.
I didn't think you were printing them out, so I kind of just didn't document it.
So we get this pen.
Sorry.
Oh, excuse me. Thank you so much. Bye. Put you back.
I played the date in the military for
I know. Yes, girl.
It's such a habit. You wrote GR 24 on
Oh, we look at GR 24.
General regulation.
Here's some right up under there, take it to me. I did the date thing. Come on, sir. Okay, I think we're ready. We said 5 minutes, right? Okay. All right, so, we said that, you know, he came, he said, I think I might need a lawyer, police, they spoke to me and gave a statement, raised my rights, okay? And now, we've received, and our client is now in custody, okay, he's in custody, right? And we just received a copy of the information that's been filed by the prosecutor's office, okay? And so now we know for certain what our client has been charged with and what for. Now, do we need another category? Did I file?
Received charges.
Information. What are we gonna call this? But what's this an example of? So we have documents that are filed in a case. What are those documents called? Anybody know? So that's an example of a charging document. The larger category in which this document is legal document. Legal document. So you're on the right path. What are we going to call this legal document once they're filed in a case? Please. Please. Right? Okay.
Sure, put that on the top.
So we might put this on a path and we got the language, get some more. All right. So formally, can I give you the information that we have? So we just on our client is in custody, has indeed been charged. Charging documents, our information. All right. So formulating our plan of investigation. Start with what we already know. Okay. So at a baseline level, we want to just kind of look at the information that we have, which basically becomes from our client, right? Our client is a source of a lot of good information for us, okay? Identify some goals. What do we want to accomplish? We want to identify some possible sources of information outside of our client. And then we want to have an organized and logical plan of action in terms of how we're going to investigate our case. You okay with this so far? Let's get it. So other possible sources of information, we got our client. Eventually got the opposing party, right? In terms of contacting their witnesses, getting discovery and so forth from them. Eyewitnesses, non-eyewitness information sources, the scene, site, or thing involved in the incident, public documents, private documents, experts, okay? These all might be some possible sources of information for us. All right, that idea? So we're just talking about some pieces of information that we're going to use to help us draft our investigation plan, okay? All right. So how are we going to draft our plan? Are we going to have a chronological to-do list? Are we going to have it categorized by topics? Are we going to have it categorized by sources? Or are we going to have it categorized by the cause of action? This would be like if we had multiple different types of claims, probably more so in like a fraud case maybe, we had different counts, right? Or if we had a whole bunch of different victims, then we might try to organize our investigation plan by some sort of scheme like that. That's probably not going to be the best strategy for our case, okay? All right. Limitations of the plan of investigation. So as we're coming up with our investigation plan, we gotta think about sometimes, some of the issues that we wanna kind of be aware of, okay? The amount of work actually required. It can look pretty big and intimidating when we start to look at how much we have to do to kind of get our case going, right? And start to investigate this case, all right? But we're gonna push past that, okay? The cost of the work to be done. Sometimes that's a factor. Because again, depending upon what agency you're with or what law office you're with, maybe funds are kind of limited. You with me? So maybe we gotta do this on a low budget, so we wanna make sure we're being very cost effective with resources and time. The value of the case itself, in civil arena, plaintiff, we're only seeking about $20,000 or something, right? Do we really wanna spend $50,000 on an expert, right? That sort of analysis. The resources of the client, okay? Resources of the law office, client authorization, so all those are different factors that are gonna come into play in terms of thinking about what might limit our investigation. Or at least things that we should have in the background. Information in an evidence log. So we talked about one of the categories we have over here is discovery evidence, right? So as we're going through this process of collecting pieces of information, collecting documents, well, we gotta have an idea or a way that we're gonna categorize and catalog how we got that. This is so huge and so critical because one of the things we're gonna talk about is, say, for example, these documents right here. Let's say that these are Babette, that's our victim. Let's say these are medical records. With me? So we just got, we were just provided for the course of discovery from the prosecutor's office, this stack of medical records. Okay? Here you go, what you gonna do with that? You gonna file it? How you gonna file? Talk to me about what you mean that you're gonna file it.
Okay, so you just presented this.
You're the paralegal in my office, we just got the discovery in, what are you gonna do with it?
First of all, I would, not file. I would, start an investigation. That's my.
Let's assume that we got the case, we're working on this case right now, okay? This is your case, right? He's our client, and, prosecutors filed charges, right? He's retained our firm to represent him, we have the information, and now, piece by piece, they're giving us, discovery and evidence in the case as they give it in. So you just got this in. What are you gonna do?
Well, the first step would be to,
Oh, I'm sorry. Did I tell you guys you could pass? If you like, okay, we're starting on passing. Did I take, so you can pass? Or you can volunteer here?
oh, okay, well, I can give it a shot.
Thank you, sir.
I will start out by researching the law first,
Okay,
in defense of the client.
all right. Okay, so pass those documents to Kylie right here. All right, what are you gonna do with those documents, ma'am?
I feel like I should, mark them down what I did get.
All right,
That's good.
That's important.
okay.
And then, I don't know, see if they are originals.
Now, why does it really matter if it's the original?
To see if it's legitimate.
Okay, interesting. Why else would it matter if it's the original?
Is there?
To know other people have copies too as well, if they're public.
Right, okay, no, but because here's the thing. Do I want to mark on those originals? No. But even if I know they're copies, do I want to mark on those? Probably not. So the process is going to be a little bit different depending upon which office you're in. Let me talk about a couple of different processes, okay? So one process might be, I'm going to get these documents in, right? I'm going to immediately go to something that looks like the next page in your slide here, an evidence log. I'm going to count how many pages, I'm going to scan this in. I'm going to have a numerical count of how many pages I received. I'm going to log it in terms of the date, how many pages, what it was, a description of it, where I received it from, right? When I scanned it in, I also, in that process, probably bait stamped it too. You know what bait stamp is? The little pretty little numbers at the bottom, 00001, 00002, right? Okay? So that's one way, right? Another process, depending upon if my office is not electronic, then somewhere I'm gonna have a blank piece of paper, right? I'm gonna make a copy of at least the first document, right? Then on the copy that I made, I'm gonna put a date stamp. With me? Now I'm gonna put that copy, just a copy of the first sheet, right? Put that with a date stamp, and now I'm gonna make a copy of this entire batch of documents, okay? Then my original is gonna be put up someplace, in a file, sealed, whatever, right? And now I have what we're gonna call a working copy. That make sense? So now if I ever have to go back to the originals, I have them maintained in their original integrity, in the manner and form in which they were originally delivered to me. You okay with that? All right.
So basically, this is the initial stage. I thought we're at the research level now. This is
Don't
document
matter.
information. Oh.
Doesn't matter what stage you're at. Doesn't matter what stage you are in the process, you're always going to have some way of documenting with pristine accuracy any information you get on a case. Because what you don't want to be is responsible for the individual who received those documents, and now you can't even offer me testimony about where they came from. You with me? Yes, sir, and yes, ma'am. Yes.
I was gonna ask if it'd be at all reasonable, instead of using that log exactly, to basically put that log in a different format where it's almost like a single page brief on here's what the document was, here's what was in it, here's how many pages it was, here's when I received it, and then have those in their own section and then have the documents themselves in a different section.
So here's the thing, your process, what you do, is gonna vary very greatly, okay? But this is not exclusive of anything else. I'm still gonna have, separate from this, a memo that says all of this. On such and such date, received documents from so-and-so, blah, 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 attached documents, did initial review, probably need to follow up, looks like medical records are missing from dates to dates, you follow me? So I'm still gonna have a memo, right? But I don't wanna have to go find a damn memo just to see what all I have in a case. So I'm still gonna have something that looks like this that tells me what is everything that I've collected over the history of this case here. Does that make sense?
Yeah.
All right. Okay. So now let's take a look at that second handout that I gave you. I didn't give you so many handouts. I don't know if it was the second one. But it's the one that says case staffing on there. At the very top, it says case staffing agenda, Tuesday, October 7th, 2014. You right, Liz? All right. So here are some things that I want you to be thinking about and to have the backdrop of when you sort of start to do brainstorming about putting your investigation plan together, right? When we come on Thursday, let's have a crafting of this and let's sort of share what you came up with. All right. So that's our plan. You know where we're going? Okay? Yeah? Huh? No, wait, I'm sorry. When I think I'll let my have that idea. All right. But you understand where we're at right now? Okay, so we're just beginning to roll up our sleeves and try to work on our finance case. Okay? So on Thursday, when you come back, your homework was being done on Thursday is for you to figure out how to use these, create your labels for your folder. Don't put rowdy on the cake. Because when we call our clients to the stand, are we going to call them rowdy? Rowdy out loud. Really do about the jury. Who's accused of murdering?
Call out loud, stand.
So what was the display plan?
So we're going to call him by his name, Herman. Correct. Okay. All right. So let's put that on there. So Stacy, Herman, whatever, right? Now we have a case number. So we're going to put that on there too. Everybody with this? You label your file. What you can do is take one of the labels and have your name on it, and it can just go on the inside here, okay? So like I said, you're only gonna learn from as much of this exercise as you're willing to put into it. The more you treat it like real workplace, then the more you'll learn, and the more you'll get out of this, okay? So think about that with your work product. Which brings me to one of the comments I made on your exercises that I gave back. Someone wrote, like, you wrote to me in the document saying, I hope this is what you wanted, and I put, this is your work product, don't write me letters. Okay, so treat it like your actual work product, all right? So you don't want some balled up wrinkled papers up in here. That's not how you're gonna give this to your supervising attorney. You have to come in and have a case stacking. You're gonna come in, be very professional. You're gonna have an outline here. Yeah, it looks like the last, here's where I am in this case. Last time we met, right? We spoke about, following up on witness, Jody Carmichael. She is actually in the state. I have an appointment set up with her roadblock, right? We're gonna practice write those memos that we wrote for the attorney. We're gonna do memos like that because every single time we contact a witness, in our log here, we're gonna make a quick little note. Contact the witness, set up appointment. With me? Then in addition to that, we're gonna have a memo that talks about the details of that interview. Okay, and a summary of that interview.
Now, each of these steps we are doing in class, so we aren't doing the case setup onward, or we're just going step by step in class and then putting it forward together.
No, you have this one time wrong. But we're at the end, we're gonna do some pieces in class though.
Okay, so I shouldn't get ahead of what,
You
how
should,
far we
you can do that as much as, so right now, there's a lot that you can do. So right now, you gotta get your file together, you're gonna do that outside of class. Right now, you're gonna start drafting your investigation plan. So you gotta figure out what's my investigation plan gonna look like. There are lots of examples in your text. I wrote down the pages on that document where you can find examples. So figure out what you want your investigation plan to look like. Beyond just the mere categories, just the bones of it, you actually gotta put the substance in here. Look at what our client told you. Based upon the information we have from our client right now, where should we start? Which witnesses from our client's statement do we want to start contacting? That Jack Gates looks pretty interesting, didn't he? So he's gonna be our witnesses, right? Maybe we want to run some background checks about our witnesses. You know what I mean? Yes.
So when we're kind of brainstorming for these investigation plans, we want to include, do we actually want to include that in this document or whatever we're turning into together? Or is that just on our own?
No, so when you actually complete your when you turn in this project, you're gonna have in your investigation plan.
Okay.
I don't need to see your draft, I don't wanna see your final product.
okay, yeah, that's what I meant, like, so all the notes and whatnot.
All your
You're gonna
notes
do on our-
and all of that stuff, like, so for example, when you get to doing your witness interview, you take your notes to their witness interview, whatever, you can keep those notes, right? But you're actually gonna write up and type a memo of that, and that's gonna go in your file here. Does that make sense? All right. You guys, we're so early. Are you guys okay? How you feel?
I still have a question.
Come on, yeah, this is the time.
Okay, so we're gonna go over memos to clients in the next class, but I'm kind of already taken a different class in relation to that, so can I type up my memo before class?
Absolutely.
Do all that stuff.
Absolutely. So the next piece is on Thursday, the next piece is actually the witnesses. So I'll tell you a little bit about what we're gonna do. So we're gonna role play the witnesses for each other, all right? Okay? So that means that we're gonna get some scripts, all right? When I give you your script, you have to really honor the integrity of the assignment, okay? Because a lot of this also is about using those interviewing and investigation skills and you being able to come up with the questions that you need to ask this person and get the information. So if you just say, oh, who are you interviewing? Melanie? Okay, I'm Melanie, here's my script. Then that's not gonna really be helpful, right? So the task is you have to actually play the role of that witness, and it's gonna be very specific. It's gonna say, here's the information this witness will give voluntarily if you ask the right questions, right? Here's the information, you will have to really make sure you ask the right question to get this. So you wanna make sure that you're following along, and you're not just giving out golden nuggets without the interviewing asking the right question, okay? All right, do you have any more questions right now? Gosh, I should have been slower, we got 50 minutes. Are you gonna be sad if I let you go early?
I think I can live.
What are you gonna do in 50 minutes? You're gonna, all right. Okay, so I will see you all on Thursday again, okay? All right, come back with your file. For some, I don't know where I posted them, but I went to look for them, I couldn't find them, so I'm gonna
It was
fix
there.
that. It was
I
there?
checked.
Okay.
Yeah, I got an email saying that you posted it.
Okay, I must have did something, so I'll make sure, I'll go back and look at, what else? Maybe I'll. Yes, if you are not here,
I walked in like 5 minutes.
please let me know so I can give you your thing, your name. All right, here you go.
I was just gonna ask, I have a lot of experience using Expando file folders for organizing stuff.
Uh-huh.
Would that be okay to turn in?